Good afternoon, everybody. Welcome, everyone who's joined us today for this really important webinar. I'm Steve Allegrezza, Executive Director of IHFRA. I'm excited to guide us through today's discussion. Thanks for taking some time out of your very busy schedule to be with us. We're honored today to have two eminent guests from SFBBG. I'm not going to go into the long version of the firm's name, but it is the go-to law firm for sales representatives. Their firm is based in Chicago and renowned for its prowess in labor laws and its dedication to guiding businesses through legal intricacies. Please welcome Adam Glazer and Adam Maxwell, who will bring a wealth of knowledge and expertise to our conversation today. Today, we're going to discuss the changes in tax laws affecting independent contractors. And we're going to focus on something called the final rule, which was under the Fair Labor Standards Act. And today we're going to talk about a few different aspects of it. So the criteria for independent contractor classification, the importance of representation agreements and contracts, compliance considerations, consequences for any misclassifications, and safeguarding independent contractor status. So now, without further ado, I'm going to hand over the reins to Adam Glazer to kickstart our discussion. The floor is yours. But actually, before I turn it over to you, I want to share with everybody that we're using a tool today called Slido. I'm sending a link here in the chat for everybody. At any point, if you have questions for Adam, feel free to use that link. You can ask the question and we'll have an interactive discussion towards the end of the session where you can upvote the questions that are most relevant, most important to you. And that way we can utilize our time with Adam Maxwell and Adam Glazer most effectively. So be sure to follow that link, join the discussion, ask your questions. And with that, I'll turn it over to Adam.
Thank you, Steve. It's great to be with you again. I recognize a lot of the names and a couple of the faces. I've worked with some of you before, and I'm very excited to have another opportunity to speak to all of my friends here at IHFRA. And it's a pleasure to do this. Questions, of course, are very welcome. So please do use that new cool feature that Steve is introducing because it will certainly help the discussion today. It is a very important topic. It's very timely, of course, because the new rule just took effect. It's a 95-page rule that we're going to try to boil down to some understandable bites. Everybody can appreciate the significance of it. Maintaining your independent contractor status is important on a number of levels, not only for tax purposes, but as Adam will further explain, it's very important for your principals, for your suppliers to observe the new rules, because it obviously affects them. They're the ones who stand to get penalized in the sense that if you're not independent contractors and the IRS or the Department of Labor or a state body considers you to be an employee under their standards, they're the ones who all of a sudden have to treat you as an employee. And that means, of course, benefits, insurance, and so forth. But we'll get into all of that in just a minute. I have invited my colleague, my partner, Adam Maxwell, to join us because Adam has an extensive background in employment law. And it reminds me of the recent story I heard when a lawyer and a pope passed away on the very same day. And they both, of course, went up to the pearly gates and were greeted by St. Peter. And at the pearly gates, St. Peter welcomed them, took them both in, showed them around, and took them to their accommodations. And he first took them to a rather Spartan room with a cement floor and a cot and no real window to look out and a cupboard, and told them that this was the Pope's room. And then he took the lawyer down the hall to his quarters, which were downright plush. There was a king bed, there was a refrigerator, there was a television, there was a beautiful view. And the lawyer turned to St. Peter and said, "You must have made some mistake. This must be the Pope's room." And St. Peter smiled and looked at him and said, "No, my friend, we've got lots of popes up here, but you're our first lawyer. So I bring that up because it is almost as hard to find somebody who is as steeped in employment law and rep law as it is to find a lawyer who is eligible to go up to the pearly gates. And Adam Maxwell has those dual skills. He has an employment law background, and he has, since he joined our firm several years ago, he's also become one of my go-to people on issues regarding sales rep law. He knows both sides of this, and he's going to be very familiar with the topic, and he's going to be able to take us through the rest of it today. So Adam is going to talk about the conundrum that faces independent contractors in light of the a new rule that just took effect earlier this week. So let me introduce you to and allow you to get to know Adam Maxwell and hear about the subject matter for today's discussion, a subject that's near and dear not only to sales reps, but as I mentioned before, to principals. Adam.
Yeah, thanks, Adam. And thanks, Steve, for the introduction. I guess it is to be determined whether I will be at the pearly gates, but I'm definitely here. And I do have the experience for an employment background as well as sales rep issues and commission recovery and the like. So happy to be here and happy to be a resource for you. We can dive into the presentation. I do have the Slido up, so I'll try to reference those as we go along. If that's the intent, Steve, or if you want to wait until the end and wait for audience to kind of upvote those items, then we can do that as well. Whatever you prefer in that regard.
Sure. I think we should get through your presentation first, and if people are engaging with the Slido, we can certainly we'll wait till the end and see which questions have been upvoted the most, I think.
Okay, great. So I'll plan to do that. I will share with you, we prepared a short PowerPoint presentation. It's got our contact information on there. It will be the first and the last slide, so you don't necessarily need to jot it down right now, but there it is. Is that working for everyone? All right, great.
I can see it.
So I'm seeing some head nods, so that's good. So I guess at the outset, as lawyers always do, the webinar is not intended to provide legal advice or establish an attorney-client relationship. These are general changes to the rules and regulations. Legal advice is obviously rendered on a case-by-case basis and as it applies to circumstances that are unique to you. So take this with a grain of salt, but these are the contours of the new Department of Labor rule that was issued earlier this year in January and became effective, as Adam just mentioned, on Monday of this week, March 11th. So we'll start it off. This is what we're going to sort of cover here, an overview. Our aim today is just to provide you with an understanding of the tests that are employed by government entities to determine independent contractor status. That will, as Adam mentioned, include an overview of tax laws. We'll touch a little bit on state laws that also apply. And we will, of course, cover the new rule issued by the Department of Labor. So we'll talk about the alterations to the rule, how it's sort of been revised, a little bit of the history in that regard, just to give you an understanding. But the overarching issue here in the presentation, and the point of the presentation, if nothing else, is to let you know that the government generally wants more working relationships to be employment relationships. That's for a variety of reasons. It captures more tax revenue, it offers additional protections to workers, and workers, this is largely driven in part by the gig economy, but workers, especially those gig economy workers, are trending away from employment relationships because they value, like many independent sales reps do, the freedom and independence of the relationship. And so there's definitely some friction there, but the new rule is a bit more employee friendly than it has ever been. And so there will be more classifications on the employment side versus an independent contractor. we expect. So the key differences between contractors and employees, this is sort of obvious, but the control and independence of the relationship, who manages, who has control over the worker. And when I say worker, I mean the person performing services, person or business performing services. That could be an independent contractor or an employee. So who has the control? Who is independent? The key differences also are with respect to taxation and benefits, obviously. In the tax realm, the principal or the employer will pay the taxes versus in an independent contractor relationship, you will pay often self-employment taxes or some other business level taxes. There are employment laws that apply to the employment relationship to an employee. Those particular laws do not apply to, independent contractors. So those are some of the protections I mentioned, like the Fair Labor Standards Act, state level wage and hour laws, FMLA, Title VII, so anti-discrimination. Those only apply to employees, not to independent contractors. And then, of course, another key difference in a lot of circumstances, although not in all circumstances, is with respect to the duration and the nature of work performed. An employment relationship is typically ongoing, might be indefinite, with the expectation of continued work as long as both parties agree, whether that's at will or under a contract for a duration of employment. And independent contractors oftentimes, although again, not always the case, is project-based or line-based, for example. It may not necessarily imply a long-term commitment, but it's definitely more specific. So before we get to the new Department of Labor rule, who is looking at this worker classification issue? So there are various governing bodies that look at this, and governmental bodies as well. The IRS is certainly one. This started where the government sort of developed task forces to look at the misclassification issue most recently in 2009, and it has been ramping up since then. What they recognized was that they were losing about $4.5 billion with a B dollars in tax revenue due to improper misclassification of workers as independent contractors versus employees. And so since then, they have been ramping up their different departments as well as their enforcement efforts. And we'll get into this a little bit later. They have been coordinating investigatory and enforcement efforts with other governmental agencies. State governments are obviously looking at this as well. So when you think of the difference between the IRS and state governments, you still have the issue of taxes, but you also, in addition to that, have the issue of unemployment, insurance premiums, workers' compensation, and then the Department of Labor, of course, is what we're primarily going to discuss today. They govern employee rights, so minimum wage, overtime, a variety of different wage and hour type claims, and the new rule did come out of the wage and hour division of the Department of Labor. And last, who else is looking at this? Your competitors. And the FTC has recently indicated that it may foray into the area of improper classification. That's a recent development. They're not officially looking at it, but I would expect that is going to become part of the equation in the future. So there's definitely, as this picture suggests, a lot of eyeballs on this issue currently. So there are varying tests, which is the bad news, because it's a little bit confusing and a little bit complex. But we can start with the Department of Labor. As we mentioned, there is a new rule that was effective this week. We will cover that. This initial rule was published as a proposed rule back in 2022. The process is that they will take comments on it and then revise and publish a final rule, which they did on January 10th of this year. And like I said, became effective this week. The IRS currently uses a common law control test that they previously used a 20-factor test. That was a very unwieldy test to go through to determine whether a worker was properly or improperly categorized as an employee or an independent contractor. They have since backed away from that 20-factor test and are using categories that generally are using factors that generally fall into three categories. One is who has the behavioral control, two, who has the financial control, and then three, they're looking at the nature of the relationship between the parties. State agencies use something, well, a lot of state agencies use something called an ABC test or some modified version thereof. It's a bit too granular to go into for this type of presentation, but what you need to know is, unfortunately, the way that it is right now, the IRS, the Department of Labor, and state agencies all use separate tests and classify workers as independent contractors for purposes of employment tax purposes, wage and hour laws, and for other reasons. And it is possible that a worker can be classified as an independent contractor by one agency and classified as an employee by another. So that is complicated, that is confusing, that is frustrating. It is frustrating for attorneys as well. They are moving closer to using similar factors, but the tests still remain distinct. And this new rule at the Department of Labor did not do any favors in sort of glossing the tests or combining the tests or meshing the tests together. So they do remain distinct. Obviously, it creates a little bit of risk and uncertainty in the business and labor market, which is never a good thing. So we'll cover the Department of Labor test here today. I highlighted it here in red on the slide, and we will go through the various factors that the Department of Labor is now currently looking at. And before we get to the details of the test, this comes out of, as I mentioned earlier, the wage and hour division of the Department of Labor. Up here on this slide is a Department of Labor organizational chart, and I've circled in red sort of the small piece of this. That is the wage and hour division. So there are many divisions within the department, but that is the wage and hour division. And that is from where this rule came. And the wage and hour division looks at these types of issues: minimum wage, overtime pay, benefits, and record keeping. So it's really focused on employment and worker relationships. So this is how the Department of Labor has now defined the term independent contractor. This is directly from the rule, and the rule is 95 pages or so. I'm not sure if you can still see me, but it's a pretty thick document here in the Code of Federal Regulations. But the term independent contractor is clearly defined as a worker who works as a matter of economic reality. That worker is not economically dependent on an employer for work, and they are in business for themselves. So economic dependence, here highlighted in red on the slide, is the ultimate inquiry. The factors that the Department of Labor uses are in the bullet points below that that red highlight. So we'll go through these, but just quickly, it's an opportunity for profit or loss depending on managerial skill. It's the first factor. I call this a 6+1 factor test because there are 6 factors that are identified, and then there's the +1, which is additional factors. So anything else that could possibly be considered in determining whether a worker is an independent contractor or an employee under the new test can also be considered. that will be helpful in a lot of circumstances in light of these other six identified factors. So the second one is the investments, and we'll get into a little bit of the nitty gritty on what is considered and what questions are asked in determining each of these factors. The third is the degree of permanence of the work relationship. And then, of course, what everyone is most familiar with, the nature and degree of control that is exercised by a principal. And then the extent to which the work is performed is an integral part of the business. And then the skill and initiative of the worker. These are the things that the department, the new rule and the department will be looking at to make classifications for employees or independent contractors going forward. So the first, we can dive into sort of these factors. Now, I put up here some of the questions that are taken from the analysis, the 95-page analysis that the Department of Labor put out that inform on each of these factors. So if a worker has no opportunity for profit or loss, then the factor suggests that the worker is an employee, properly categorized as an employee. So on the flip side, obviously, if a worker can suffer a loss in connection with their business, or if they have the opportunity for profit, then that suggests that they are an independent contractor. So can the worker determine or meaningfully negotiate the charge or pay for the work provided? That's one of the items that the Department of Labor would ask, for example, in an audit or in response to a complaint that has been lodged in connection with this particular factor. Does the worker accept or decline jobs and determine when the work is performed? Do they engage in their own marketing, advertising? So do they appear like a business? Do they operate like a business would? Or are they relying, oops, sorry about that. Are they relying on the principal for that, essentially to feed it or that worker? Does the worker make decisions to hire others, purchase materials and equipment, or rent space? So that's those questions all inform on whether there's an opportunity for profit or loss. The next factor that the Department of Labor rule discusses is the investments. Investments in the business. So investments that are capital or entrepreneurial in nature generally support an independent contractor status. This is considered on a relative basis, so it does not need to be equal to the principal's investments in their own business, for example. It's not compared necessarily in terms of dollar values. The focus is on, is the worker who is being categorized, the focus is on, is that worker making investments that suggest the worker is operating independently? So it doesn't mean that there has to be hundreds of thousands of dollars of investment in the business because the principal is making those types of investments in its own business. Rather, we're looking at, and the department will be looking at, whether the investments increase the ability to do different or more work, whether they reduce costs, and whether they extend market reach. The degree of permanence is also a factor. So how long, what is the duration? A relationship that weighs in favor of employment is indefinite in duration. So typically an employee who is working for an employer, that relationship is not defined. It's usually at will, and it says, you know, we'll continue until we won't anymore. That's the nature of an at-will employment situation. So if it's indefinite, there's no term, for example. If it's continuous and if it's exclusive of work for others, those all weigh in factor of employment. In an independent contractor relationship, typically, and what we definitely will be recommending in light of these new factors, is that there are terms for the duration of the relationship. Now, those terms can certainly renew, and they can even renew automatically. But You want to have a definite term associated with the relationship with principals in light of the new factor or the new rule. The next factor is control. So who controls the performance of the work and the economic aspects of the working relationship? The inquiries here are who is setting the schedule, if anyone, who is supervising, and is this limiting of work for others? This includes whether the company uses technology to supervise the performance of the work or reserve the right to, for example, discipline workers. It includes control over prices or rates for services, the marketing of services or products. And then it is worthy of noting, because we've seen this a lot in the industry, that compliance-related control items are not indicative of control. So one thing that has been sort of recent, started about 5 years ago, and there have been some updates to the GDPR with respect to data privacy and management of that type of information. Compliance-related control items like that do not inform on the level of control under this test. So as many reps experienced when getting back on the road after COVID, a lot of factories were requiring sort of detailed reports on where the reps have been, who they've seen, what they're doing. Some of that was under the guise of contract tracing, and then some of that hung around. That type of supervision, and sometimes even digital supervision, it has been a little bit more common. And I understand certainly that many reps want to distance themselves from that type of reporting because it's burdensome. It's not really industry standard, among other things. Like, you do want to conduct your own business and not fill out reports. And these new rules provide you with a basis to push back on those type of items. You could say, you really don't want this to exercise this type of control over me and over my business, because I am independent. And if I am classified as an employee, that is to the principal, detriment. And you can say things like, you're requiring of me things that are more likely relate to an employment relationship. That's certainly not something that you want, and it's certainly not something that likely they want either. So it does provide you with a little bit of a basis to push back on those types of items. I see some questions coming in, so I'll wait until the end to address those. But the next factor is whether the work is an integral part of the business. If the function being performed is an integral part of the business, it weighs in favor of the worker being an employee. So that is, and I should note too, I didn't say this at the outset, none of these factors, none of these 6+1 factors are given more weight than any other factor. So it doesn't mean that, and it doesn't necessarily mean that if 4 of the 6 factors weigh in favor of an employment relationship, it does not necessarily mean that a worker will be classified as an employee. There could be a 5th factor that is much more important in light of the circumstances or the nature of the relationship that would lean heavily in favor of an independent contractor relationship. So none of these factors are dispositive. They will be interpreted and examined under a totality of the circumstances analysis. So we'll look at everything, including, of course, the additional factors. So the skill and initiative is the next and I think 6th factor that has been defined by the Department of Labor. It's the use of specialized skills in connection with business-like initiative and indicates independence as opposed to an employment relationship. So if the worker is dependent upon training by the potential employer, that leans in favor of employment, versus an independent contractor who already has the specialized skills and the business-like initiative to go out, do the job without any training, then that is more likely to lean in favor of independence and an independent contractor. The additional factors, this is anything really that indicates a worker that is in business for themselves, as opposed to being economically dependent on a principal. So that sort of leaves the door wide open for additional factors. And the reason that they have to sort of include that is because from industry to industry, obviously, there will be different factors that will weigh on whether the relationship is an independent one or an employment relationship. So that's all to say that the 6 identified factors sort of skew slightly in favor, you can probably tell, of an employment relationship. That's consistent with the Department of Labor's historically pro-employee interpretation of prior court decisions on this subject. That's sort of their job. They're charged with enforcing worker protection laws. So of course they're going to see things in a pro-employee and pro-employment manner. But it is important to note that the way that the law works in the United States is that existing court decisions and not the Department of Labor rule will continue to control proper classification of workers. This new rule, of course, will be cited and relied on as persuasive authority in federal courts and may impact the shape of the law going forward, but certainly the Department of Labor in its audits and in its enforcement efforts will be relying on the new rule undoubtedly. So it will shape wage and hour law into the future, and we're going to get into a little bit of the more concerning portion of this right now, which is just highlighting the fact that there's coordinated government action on this particular issue. So it's always a little bit concerning to see 2 agencies that don't necessarily have the same objectives cooperating, and they are definitely cooperating on this misclassification issue. So the IRS and the Department of Labor actually executed a memorandum of understanding for employment tax referrals. That just establishes a system of referrals from the Department of Labor and the IRS. It's just designed, I mean, the whole design of the program is to assist in identification of employment tax compliant issues related to misclassification. So they're freely exchanging information. The practical effect of this interagency agreement is to streamline the process for investigating and penalizing businesses that allegedly misclassify their employees as independent contractors. The memorandum of understanding, it was executed in December of 2022. That's shortly after the proposed rule came out. And so we will see, we believe, a lot more coordinated action and enforcement efforts between the IRS and the Department of Labor. Now, the memorandum does make clear that the IRS is targeting businesses that lack a good faith basis for their worker classification, and those businesses are more likely then to be on the hook for substantial penalties. Now, it is concerning enough that the IRS and the Department of Labor have entered into this agreement, but also the Department of Labor has entered into similar memoranda of understanding with the Department of Labor, state level Department of Labor organizations and agencies to share information with the IRS as well, and with these state governments. So the Wage and Hour Division is sharing this employment data and coordinating misclassification and investigation efforts. You can see the problem because the IRS and state agencies, to a large extent, have all of the information, and they use data-driven approaches to identify whether there is improper classification of workers going on. That's problematic because the IRS uses a different test than the Department of Labor does, and so do state agencies, as we previously mentioned. So the Department of Labor is using common law, or I'm sorry, the IRS is using common law standards, behavioral, financial control, and the relationship of the parties. The Department of Labor is now using their own test. States are using the ABC test or some modification thereof. And so it makes determining worker classification a complex issue. It makes compliance a complex issue. It's a high level of coordinated activity by the government. It's been in process for a long while. The effect of this has been delayed by not having a final rule in place, but now that the final rule is in place, we're expecting to see increased activity here. So what you may see as a rep, you may see principals, and just to be clear, most of the exposure here, in fact, almost all of the exposure here is for principals. All of the rules are designed to impose penalties on businesses that misclassify their workforce. It is not designed to penalize an individual or a business that is operating as an independent contractor or as an employee. It's not designed to penalize employees. It's designed to protect employees. So what you may see here is principals getting nervous about the increased activity, looking to change terms of contracts to better follow these factors and recite that that you have an independent contractor relationship, and you don't have the control, or they don't exercise control, and things like that, or to introduce ancillary contracts due to the increased risk here. There's certainly in the market, there's a lot of nervousness about compliance. But again, most of the risk is with the principals. So that is sort of what you may expect to see. There are certainly times that are better than others to try to negotiate written contracts. This is one of them. So some of the best times to renegotiate a contract is obviously in advance of renewal, or if you're doing some succession planning, if there's proposed amendments, if there's performance or quality issues, or some type of market change, or if there's some type of growth or restructuring within your organization or the principal's organization. But certainly also one of the times that is better to negotiate contracts and seek improved terms, not just with respect to this, but in general with respect to termination or commissions, is when compliance concerns are raised. So there will be an opportunity to sort of negotiate. There's many ways to do it. You can do it on your own with advice of counsel. You can do it on your own without advice of counsel. You can have counsel ghostwrite, or you can have an attorney out front. I generally don't recommend getting an attorney out front to negotiate a contract unless the principal also has an attorney out front. Just sort of unnecessarily escalates things in most circumstances and complicates things. But it's advisable when another party, or the party you're negotiating with, obviously has an attorney involved as well. So the significance of having a written agreement here, it's obviously going to establish that the nature of the relationship. It will provide a little bit of clarity in the expectations. It will provide and help establish a good faith defense for principals to in the event of an audit or a misclassification enforcement action. And then, of course, for purposes of reference, it's always a good idea. You can always reference the terms of the contract for your day-to-day. I know that the joke is that reps usually look at their contract when they sign it and then when they're terminated as well. But it can be helpful to have these items, or many of these items, in writing so that you can say, hey, they're trying to exercise some control over me. I'll look at this term of the contract that says you actually can't do that or shouldn't do that. So some compliance strategies, our recommendation is to follow the federal, state, and local guidelines as closely as possible. They do have varying tests, as I mentioned, but you can sort of weave and mesh those together as best you can. But primarily, the best practice is going to be to maintain documents that support a proper classification. That will include using a written agreement, implementing policies and procedures, having a good faith basis. These are sort of related. And then getting the advice of counsel if you need it to sort of develop a good faith basis or to negotiate contracts. Some of the methods to maintain your independence as an independent contractor, these overlap, but use written contracts, invoice for services rendered. That establishes a little bit more of an independent relationship. Utilize separate business entities, make the appropriate investments in your business, avoid dependence on one client, maintain control, be informed about the law, and to seek advice when necessary. So that's sort of the high level suggestions that we've got for sort of navigating this area at this time. The bottom line is that the classification issue and the misclassification issue remains complex. Unfortunately, it doesn't look like we're going to see many big strides in a unified approach to this issue in the near future. It could happen, but it's definitely down the line. Documentation and contracts are going to matter, and of course, stay informed and be proactive about this. So you can steer clear of getting caught up in these types of investigatory matters. And so, that's sort of the best advice we have right now. It is a brand new rule. So the factors are sort of always changing. It's a bit more pro-employment now. And we do expect to see a little bit more government activity by way of audits and enforcement. There are a lot of additional resources available on the Department of Labor website, as well as our firm's website. I'm happy to be a resource, so please reach out with any further questions or feedback. And here's our contact information again, as I suggested. It'll be on the front and the back, and then I know IHFRA will circulate that, and I think it's been on the materials already. But thank you for your time so far and your time and attention. It's an important issue. I hope you got some value out of the information, and you have a way to sort of navigate this and some ideas on how to navigate this and what the landscape may look like going forward. And I know there were some questions that came in. It looks like they've all got one vote, Steve. So
sure. And here, let me do this if it's okay with you. I'm going to share a screen real quick in case anyone wants to jump in and join that conversation, upvote anything else. Let me just do this real quick. Maybe it'll prompt some more questions. There we go. Now everyone should hopefully see my screen. There's a QR code that anyone can scan at this point to jump in to the conversation, ask questions, certainly upvote them. And maybe, Adam, if you want to tackle the first one, I see that it's got 2 votes. We can start there and go from there.
Sure. Yeah. So if a rep represents multiple lines, as is common, could they be considered an employee by one factory because of their rules of reporting while independent from others? So the answer is likely yes, but again, just because of rules on reporting would not necessarily determine the nature of the classification, so whether they're independent or an employee. But it is possible that an employee that a worker could be categorized as an employee by one state government, for example, and not another state's government. So even from state to state, the agencies that look at this use varying tests. So the sort of the prevailing test is what's called an ABC test, but many states use a modification to that test as well, which introduces different factors or negates some of the factors, or, for example, only uses A and C of the ABC test. And so there is definitely a possibility for varying classifications from state to state and from state to federal in terms of the departments of revenue versus the IRS and the Department of Labor, and even state level departments of labor. So the next question, I think these are just in sequential order. If a rep calls, let's see.
Sorry, I'm going to go ahead and mark ones off that we answer here. So,
Oh, I see. I was wondering, it disappeared. All right. So if a rep calls on clients in states outside of their resident state and earns income from that transaction, does it count as income earned in another state? I don't know the answer to that question. That's a sort of a tax question, and I'm not 100% sure on that.
Because the laws vary from state to state, you know, it all depends on the states that are involved. Generally speaking, that is a tax question, and it's one you should raise with an accountant. But certainly, California, for example, is very sensitive on this issue, and income earned in California can require the filing of a California tax return. Can, not will, but can. So these are all that's a very particularized question. It's going to depend on a lot of other factors that's beyond the scope of this webinar today, but it's a question that should properly be directed to your accountant.
The next question is, will we make available a copy of the PowerPoint to review with business partners, team members? We typically do not do that because of the risk associated with relying on information contained in the presentation, because lawyers sort of have ethical obligations to not provide legal advice, and it can be misconstrued. So we typically do not make PowerPoint presentations available, but we do have the resources. And I saw that there was another question: where can I find the resources you mentioned on your website to learn more? We can certainly circulate that type of information. It's been through all of our ethics reviews and sort of vetted for that type of reliance analysis. So we can do that, and we will circulate that information. A lot of it is contained in the presentation, but the presentation is a little bit different in terms of making high-level, recommendations, things like that.
okay, I'm going to go ahead and mark off that other question. So
the next question is, can you please redefine what you mean by term, or what you meant by term? We don't have agreed terms with our vendors. If term means the length of time that we will provide work. So yes, that is what I mean. It is the duration of the relationship. And so what a lot of independent contractor agreements do to establish an independence in that regard is they will have a specific term, a specific duration of time that the relationship, that the contract governs for the relationship. And including, well, I should say the contract will have termination provisions, but most often what happens is the contract says this will renew for an equal term subsequent to the initial term, and will continue to renew automatically. And so it appears that it is more independent in that manner under the new rules and under sort of all of each of the rules.
Adam, that of course assumes that there is a written contract, and written contracts, as you know, in the furniture industry seem to be the exception rather than the rule. So can you speak a little bit to how that would apply to oral contracts? Everybody has a contract, whether they know it or not. just a question of whether it's written or oral. And if an oral contract, typically the parties don't discuss the length of service. It just, it's a quick deal. It says go sell, and there's nothing that's agreed upon at the beginning as to how long the relationship will last.
Yeah, that's right. And so it's on a case-by-case basis. A written contract is not required for an independent contractor relationship. But this is one of the factors that is now assessed. And so, what we recommend and suggest is that if you have a written contract, it should have a term. Again, each of these factors that are being looked at and have now been developed are not alone going to determine the nature of the relationship. So if you do not have a definite term or duration for your relationship with a manufacturer, that is not going to mean that you are going to be an employee or deemed an employee, or that you're even really at risk of being deemed an employee if the other factors weigh in favor of an independent contractor relationship. So if you're making the investments in the business, if the manufacturer doesn't exercise control over you, the fact that you do not have an independent contractor written agreement with a term is not going to carry the day on how you will be classified by one of these agencies.
Let's see. All right, so I feel like the next two are kind of similar, like this one and, sorry. Talking about one asks, is it worth it to get a contract with the factory that doesn't use one? And another question says, what's my risk as a rep without a contract? So I feel like the two kind of go or are asking similar questions.
Sure. Yeah. So, the risk to a rep without a contract, I think it sort of was answered in the last question. It's one of the many factors that are considered. So it's not going to carry the day on a determination. What details? So I see there's what details should be in a contract for compliance, any tax changes needed when filing in 2024. And then there's another question that relates to that as well. What are the essential language elements that a rep should include when negotiating or updating a contract? There's no magic answer for what details should be in a contract or what language should be included in a contract. What we are generally doing, what we are generally seeing is we are trying to capture in contract or written form the nature of the relationship, accurately capture the nature of the relationship in the contract, just so that it is more clear evidence of what the nature of the relationship is. And so, of course, there will be a recital that says we are an independent contractor, that the parties do not intend to create an employment relationship. Those are worth what they're worth in terms of that, but capturing the additional items in there, like you can make representations that, yes, the rep is making investments in its business to extend market reach, that this agreement does not prohibit the rep from repping other non-competitive lines, for example, things like that. All of the items that capture sort of the nature of the relationship between a manufacturer or principal and a rep, we are adding those in to the agreement just to capture that information and have it documented. And so, in that regard, a contract does sort of elevate and become a little bit more important. The fact of a contract itself and the fact that it exists is not that important. But when you look at it and you say, all right, this accurately captures the nature of my relationship with my principal or my manufacturer, a regulator will look at that and say, okay, well, let's take a look at this representation. How do you do this? How does the manufacturer not exercise control over you, or what control does the manufacturer exercise over you? And you can show them that it's not only a matter of contract, but it's also a matter of practicality. The second, the middle question there was, is there a benefit of proffering a contract to a factory that does not use one? Yes and no. There are benefits, certainly. If you have a factory that is willing to enter into a written contract and you can get advantageous terms, then certainly there's a benefit. But if they're not willing to negotiate those terms, or if you have an oral agreement that's working for you already, maybe not. I mean, you could enter into a contract with a factory that includes a termination provision that is, and you could do this unwittingly, sort of. You could enter into a termination provision that provides you less rights as a matter of contract than you would have under an oral contract, and what's called, for example, a lot of states have a legal doctrine called the procuring cause doctrine. We use that all the time to collect unpaid or underpaid commissions, especially upon termination. And so that doctrine can operate with a contract or without a written contract. But the danger in having a written contract that has a termination provision that provides for example, a certain number of days for post-termination commissions, the effect of that contract could be that it abdicates or supplements or replaces the procuring cause doctrine to your own detriment. So it's really hard to say, but what I can tell you is, on a case-by-case and as a state-by-state basis, the contracts do look very different. There is no form contract. So what you try to do is enter into a contract that has advantageous language, or at least clear language that both parties understand, and so that the parties know their obligations and come to an agreement that's fair. That has the effect and the intent of reducing disputes, and if both parties can reach an agreement and have the intent, to agree on terms that they can both live with, that's going to reduce the likelihood of a dispute, and especially a dispute that sort of devolves into litigation, which
We know how hard it is to end up with a favorable contract in dealing with a large principal, and we're not suggesting that that's readily obtainable. So we always say that an oral contract is better than a bad written contract. We would much rather have a handshake deal than a 40-page single-spaced pro-manufacturer contract that they force you to sign.
Right. The next question is, if a factory prefers to change to an employee relationship to save money by way of less commissions versus salary and benefits, is there any recourse for independent reps? So certainly that does happen. Sometimes factories eliminate their outside sales force and take the sales force direct or in-house. Is there any recourse for independent reps? Yes. It's a matter of contract, though. So what you'd be looking at is whatever the contract provides for. So if that is, if there's an oral contract, for example, perhaps you're entitled to the procuring cause, collection of commissions based on procuring cause doctrine. Otherwise, you'd be entitled to whatever the contract provides for. But in any circumstance, I have not seen yet where a factory said, we are going to convert you to an employment relationship where the independent contractor agreed to that. They would say, no, I am an independent business. We're going to continue to do business and do it this way, or I'm not going to rep the line anymore. And that's sort of how I've seen that play out. But I've not seen a successful conversion. And in fact, the department of Labor and sort of these state agencies do not mandate that, but they will impose penalties for improper classification.
So the subject matter of this question is worthy of a separate webinar. I mean, to talk about recourse in the event of this kind of conduct when a sales force is moved direct. And we've spoken about it and we've written about it in the past, but understand that here's a good example where an oral contract would be your best friend. Because when Adam talks about the procuring cause doctrine, again, I know that sounds very illegal, but that concept is simply if you bring in business and that business is going to continue after you're terminated or after they move the sales force direct, and the manufacturer is going to continue to be able to benefit from that relationship and exploit the context that you brought in during your period of service, why should they possibly be able to do that on a commission-free basis? You've already earned the money by establishing the relationship, and because it continues after termination, the law allows in many jurisdictions for the sales reps to continue to get compensated for that, to continue to get commissioned post-termination. And in a situation like this, where you have an oral agreement, that's a situation that's ripe for seeking those kind of damages for the work that you did pre-termination. So yes, there is a recourse. We spend a good deal of time, Adam and I, pursuing that recourse on behalf of sales reps nationwide.
The next question was, are the IRS and the Department of Labor looking more at the sales rep or the factory for compliance? So these laws, especially the Department of Labor laws, are designed to correct misclassification. So they are looking at the principals. They're looking at the factories for compliance. So the audits will occur in that regard, and the enforcement actions are against entities that are misclassifying or allegedly misclassifying their workforce. And so they are not coming after contractors directly on a case-by-case basis. It wouldn't really allow for that anyway, but that's not the intent of the laws. However, the second part of this question is, could this result in certain deductions not being allowed? Yes, it could. So it does have implications for contractors to be misclassified. And so there is that risk associated with it. And that's why it's sort of a vertical inquiry here. Not only are the factories looking at this, but also so too are independent contractors. And they should be taking the steps and at least being knowledgeable about these factors to say, here are the things that the government agencies are looking at, and here are the things that I'm doing, and what can I do to better align myself and decrease my risk, whether that be with the IRS, state level Department of Revenue, or the Department of Labor, or any other agency that's looking at this. What can I do to sort of increase the likelihood that I am classified as I think I am, or as I think I am operating as an independent contractor, and taking those steps. And then the last question here is, if an independent contractor feels like the principal is treating them like an employee, what actions can they take? And that is sort of the issue. You have to be knowledgeable about what the standards are and be able to articulate and advocate for yourself and say, the risk here is that you will be deemed to be treating me like an employee. I don't think you want that for a variety of reasons. I certainly don't want it, but I don't think you want that for a variety of reasons. You would have to be keeping records with respect to wage and hour. You'd have to be paying benefits. You'd have to be doing a variety of things that you don't want to do, and that will increase the cost of you. You'd be paying payroll taxes, for example, and facing penalties. And so the risk is on you, the manufacturer, the principal, and what you're doing here is increasing your risk. And so we've seen reps successfully push back, especially on the control, where, hey, you can't tell me how to do my job. You can't tell me to attend employee meetings on a certain day at a certain time, and that I have to be there, just like your regular employees. That's not how this works. I'm independent. I do as we have written in the contract, or how we have otherwise agreed. I sell the product, and you pay me a commission, and we're both operating independent businesses. So the next question is, what if an account rep hires a sub rep and pays them a flat monthly fee? So I'm not sure. So there's a couple ways this can go. If the question is that an account rep hires a sub rep as an independent contractor and pays them a flat monthly fee, or if the account rep hires a sub rep and pays them as an employee and pays them a flat monthly fee, in either circumstance, you could do that. You could, and depending on state law, you might be able to, most states require that you pay either every other week or twice a week, or sometimes once a month for employees. But for independent contractors, this question relates to really how the payment is made and not what the nature of the relationship is. And so I believe the question is probably asking about whether the way that a sub rep is paid informs on the nature of the relationship, and it really doesn't. So you can pay employees in a variety of ways. You can pay independent contractors in a variety of ways, but generally speaking, independent contractors are going to invoice for their work, and an employee will not. And then this sort of also informs on the factor of whether there is an opportunity for profit and loss. So if the sub rep does not have an opportunity to take a loss because there's a flat monthly fee that is being guaranteed to them, that factor is going to weigh in favor of an employment relationship.
Well, I'll tell you what, Adam, just to be respectful of your time and Mr. Glazer's time, I'm going to go ahead and probably stop us right there. I think everything you shared with us has been amazing. I want to thank you both. I want to extend my gratitude for sharing your expertise and your perspectives with us today, and kind of bringing us up to speed on those changes and how, as independent contractors, our members can help themselves and help clarify these types of relationships. I also want to thank everyone for taking the time out of their busy schedule to join today's call. I'll send some follow-up emails. Adam, if it's okay with you, the resources that you can share, I'd love to be able to provide that to everyone that was on today's call. If it's okay to share a recording with them in case they want to go back and review anything. Again, if there's any issues there, let me know. And then lastly, just want to let everyone know that's on the call, we've got another webinar coming up April 5th. It'll be with some friends of ours, the Gulfstream Shippers Association, and we'll be discussing the current challenges impacting global supply chains and how those challenges impact our industry, why reps should be concerned, and how reps can help educate and advise their customers. If anyone's interested, that is available to sign up now on our website. So again, thank you all for coming out today. Genuinely appreciate your time and expertise, and we'll look forward to seeing you soon. Or actually, you guys will be, Adam, will you be attending October Market?
Yes, I'll see you all at Market in October in High Point.
Wonderful. We're looking forward to it.
Okay, thanks a lot. It's good to be with you.
Thanks so much.
You.